Felony probation is an alternative to incarceration in Louisiana that allows offenders to serve their sentence under supervision within the community. Felony probation eligibility in Louisiana depends on several factors, including the nature of the offense, criminal history, and the offender's ability to meet the conditions of probation. Generally, non-violent first-time offenders are more likely to be granted probation. However, certain offenses, such as violent crimes, sex crimes, and serious drug trafficking, often carry mandatory prison sentences or restrictions on probation eligibility. Recent changes in the law allow for third or fourth felony offenders to be placed onto probation for drug possession crimes. But typically, a third-time felon is ineligible for felony probation. In Louisiana, there are two types of felony probation: active probation and inactive probation. Active probation, this is the most common form of probation, requiring the offender to regularly report to a probation officer and comply with all conditions of probation. It is not uncommon for the offender and probation officer to be making numerous court appearances during the probationary period to ensure that the probationer is complying with the special conditions imposed by the court. Inactive probation, this is rarely imposed at the beginning of the probationary period as it allows the probationer to be unsupervised. Typically, the court will only impose monetary conditions such as fines, court costs and restitution as the special probationary condition. Probation is deemed to be satisfied upon fulfilling those conditions and refraining from new criminal conduct during the probationary period. While inactive probation is uncommon for the entire probationary period, it is not uncommon for a court to convert a person's supervisory status from active to inactive upon the passing of time with good conduct and completion of the court's special probationary conditions. Probationers must comply with standard conditions, such as reporting to a probation officer, maintaining employment, and avoiding further criminal activity. One major condition is waiving your rights to warrantless searches of your home, car or person. This means that the probation officer can come to your house unannounced and conduct a search if he feels the probationer may be using drugs or committing other illegal activities. The second, and most obvious, standard condition is to refrain from criminal conduct. It is not uncommon for probationers who are rearrested to have the court place a hold on them, preventing them from bonding out on the new charge until the new case is concluded. Special conditions may be imposed based on the specific offense, such as substance abuse treatment, community service and restitution. It is my advice that the probationer complete the special conditions as expeditiously as possible. The benefits for doing so can range from having to make fewer court appearances, converting to unsupervised probation, or even an early successful termination for probation. Violating probation terms can result in consequences, including revocation of probation and possible incarceration.